This DJ will kick the floor in 3, 2, 1.
On the troll.
Yebo, yes. Hello and welcome back to Mzansi. We're back again. It is that time where we have to talk about the case. Right, a lot of things happened in that court, and seems as if we're back to square one. Greetings. Please make sure that you press the like button as usual, and you interact with the video. And I hope that in this cold weather you are warm. That is important. You must be warm as much as you can. And yeah, we are here. We are here again and again and again and again. We are here. But let us dissect what we saw today happening in that court. I know some of you would have mixed feelings. You somehow feel conflicted. Some of you are resolute in what they wanted. Perhaps you see everything as normal. It is normal to feel any of those scenarios. It is normal to feel somehow about certain people in that court. It is normal to feel anything about whatever that is happening there. Yeah, so we were waiting for this internet to take their sweet time and reconnect back as usual. We could have been here more earlier, but into zabelunga sas noma ziphikisana nathi noma zenzani. Greetings to everyone. Take your cup and chill. Emily is gonna serve it as always. Emily does that for Mzansi people. Emily, how are you doing and how are you feeling?
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us here again in one of our deliberations of the Senzo Meyiwa trial. Now today's proceedings were very interesting. Mr. Anonymous, you're asking how I'm doing. I am okay. I'm just a bit tired. Just a bit.
Okay.
But then I'm okay. Nothing much to complain about. The High Court in Pretoria was set to hear this morning if the defense would proceed with the application to have charges dropped against the 5 men who are accused of killing Senzo Meyiwa. Now, this is after the consultations that apparently happened with legal aid who are funding the accused. From what I could hear, though, I don't think there were much consultations. It was more of a writing to legal aid and then legal aid responding. To call them consultations would be a stretch in my opinion. The defense was expected to give feedback on whether legal aid will fund Section 174 application, also known as a discharge application. And this application allows for an accused person to be discharged from the prosecution and acquitted of the charges that they are facing. And the application for a discharge is typically made by the defense after the prosecution has closed its case. And this is for the people that I keep seeing the comments of and who keep accusing the defense of dragging this case, of accused dragging this case. It's something that's supposed to happen in a court of law. Such applications can be made at the end of the state's case by the defense if they feel that they don't have a case, the state's case is not strong enough against them. So the state wrapped up its case in the Soccer Stars murder in July 2025. That was just last month, marking it like a pivotal moment in this very long-lasting trial. It's been so long, 2 years. It's been quite a while. Someone jokingly left a comment there by X to say that the state presented 68 witnesses. Out of them, only 3 were in the house. Only 3 were actually testifying about what had happened. right?
Yes.
So I found that very funny, and I'm like, oh my God, we've been listening to all these different people, and most of them actually have nothing to do with the incident that took place. It was very interesting. So Advocate George Baloyi said that the decision on whether to fund the application section 174 will be communicated to them on the 6th of August. That was said to happen yesterday, that the defense would get feedback from legal aid on the 6th of August, and that is why now today they just wanted to hear the outcome of that Committee of Legal Aid South Africa. And the defense wanted to consider a section 174 application, and they had to wait for legal aid's outcome. Now, this is a decision on whether legal aid will fund the application or not. So MNISI said that Ms. Flavia, a representative from legal aid, was in court, and later on we heard her speak. And MNISI Ramasepili, as well as Advocate Nxumalo, indicated that they received legal aid outcome, and they are yet to communicate what legal aid had said to their clients. Advocate Zandile MSHOLOLO, however, said that they have confirmed with her client that they have considered the issue of bringing the Section 174 application. She even mistakenly referred to it as Section 175. And she said, okay, Mr. Ntuli will not be bringing any application for 174. They will proceed with the defense case. This came as a surprise to me, and it really shocked me. And it also makes me wonder if some of the allegations that Advocate Diffo had made in the past have anything, to hold water on, because now I'm puzzled. I don't know how to process this, considering the fact that the defense has always assisted Advocate MSHOLOLO, especially with that application of moving accused number 5 from Hoshimampuru to Louis Kop, and how they were actively participating and they were moving in one. And now to just see her abandon this application like this, and I don't even think I understand why that application is being abandoned, especially considering that her client is said to be the one who drove away in the drive-by car. I really don't understand her decision. Mr. Anonymous, maybe it makes sense to you. Can you unpack it for us?
Yeah, it leaves a lot to be desired. I think more than just following procedures and the law itself, it seeks to be more divisive than anything. It reminded me of the journey that we have been having with accused number 5, regardless of the fact that they are now charged and they are looking at this as in a form of common purpose, right? Which in any case does not affect anything. It does not. It has no bearing, basically. But what it does, it undermines the weight that if this section 174 is given, even if it was given a go-ahead, it undermines the weight that it would have if the other accused decides to go otherwise. It's okay. You can, at the end of the day, common purpose does not mean that you are conjoined in everything that you do. The judge looks at you as individuals, and whatever that you do, in a sense, it has no bearing. What it simply means is that there could have been the talk before maybe the crime was committed, or you guys could have found each other in the same vein of crime. That's what common purpose simple means in a nutshell. But to always pull away when your weight is needed, is not helping others, because when their weight was needed to give, in fact, let me put it like this. I don't think accused number 5 was going to be given, or the ruling was going to be given to accused number 5 to move from Hosmapur if only MSHOLOLO submitted.
Yes, that's
There was no way. So it was a submission of Ramusipil and a fight of MNISI that actually got accused number 5 the verdict that he wanted. So to see Advocate MSHOLOLO pulling away, there could be many reasons. There could be a reason of maybe they decided this after receiving this, whatever that the outcome that they received. But that is, in a sense, making it look like now these are the ones who are saying we're forging on with this. They do not want to work in the eye of public, because there are many people who have their way of thinking. You know, there are many people who are pushing their own agendas. I don't think MSHOLOLO should have just waited this out, and I think went along and fought, and they all have one victory, and or they all have one lose. But MSHOLOLO, now and then, the individualism, when it suits her, it is okay. And I know many people who are supporters of MSHOLOLO. I have never been that much of a fan of MSHOLOLO, and I must say that in advance. I've never been much in support of her, and I don't look at her as a person who really has too much weight in terms of what need to be submitted in that call. Let me put it like that. I don't think MSHOLOLO has what it takes.
Her client is serving 38 years.
To actually sway the narrative in that court. Call me whatever you call me. Let us now quit the game of playing and trying to. In all honesty, if you look at what MSHOLOLO brings in that court, honestly, you sit down now, you forget about the shouting and everything. Just look at the facts that are brought in that court. I don't think with her gone or not gone, it will change anything.
She was able to be absent for how many weeks?
So many of you are not gonna like that, but for me it's a fact that I've been observing.
If you can vanish off of court like that and your presence is not missed,
what MSHOLOLO is a woman amongst men, which is always gonna be liked in any case as a woman who's standing up and also fights, and it's okay. If we look at it like that, well done MSHOLOLO. Now I was following the case of Mary, who's this Mary Pad.
Yeah,
I was not impressed there also. Now I have to say it. I mean, you could have advised your client otherwise. I mean, there was a victory that to me didn't look like a victory, because you were complaining and then you're saying you're waiting for other people. It's like you were waiting for yourself, but you call it a victory. You know, I'm still to be convinced. Obviously, we are still going to go to court and then hear arguments and all that. Let us be honest. I'm still to be convinced, but I still take her as a defense, and obvious also. But we have been mentioning it. Her client has nothing to lose. In fact, her position to me is much more looking for money than MNISI. You know, we will continue. We will bring all the witnesses, even if there are 50. We get our payments. It's okay. We appeared in court. You know, on the other side, MNISI is saying, I mean, I'm drafting for 2 people who have different scenarios. The other one is a confession. The other one, there is some gun that was tested many times that I have to look at for me to actually for me to actually draft this. It sounds crazy. When Nxumalo says a week, basically there is nothing in those records that implicates accused number four.
He doesn't have
rightfully so. A week, I think, will be enough.
Oh.
There is nothing. In fact, if anything, Nxumalo is the one, and I was happy. I'm starting to respect him. He chooses his battles very well. This battle of Section 174, it suits Nxumalo more than any one. In fact, it suits Nxumalo and accused number 5 as the runaway car, because the rest of the other ones, they have a difficult mountain to climb.
Yes.
In fact, one could argue that there is a bit of clarity that could actually help this case. We were arguing with Emil right now, saying, but the decision that was taken by the legal aid, it seems to say that there is something to answer for. And Emil does not believe that there is actually something to answer for. In fact, Emil looks at it as if the state wants to say, prove yourself that you are not guilty. We will reach there. But for now, all I'm saying is that Nxumalo, again, smartly picked up the fight. This is his fight. Here, I'm happy that he supported this motion. This is his fight. The client, Nxumalo, has not, in fact, in anyhow been implicated. That thing of what do you call it DNA. It does not exist. There is basically nothing linking accused number 4. Rightfully so, Nxumalo can actually push more. For accused number 1, for accused number 2, and accused number 3, I believe there is something that would require clarity. Remember, for Section 174, we explained it to actually be approved, not approved by legal aid, to be given by the judge as, in fact, you are right, we need to drop all these charges. There must be absolutely nothing. In this case, there is a gun, and a gun, whether it was planted, but there is a gun, and on other case, it has been proven that this gun belonged to accused number 3. And then on the other side, the other ones, there is this confessions, whether they were coerced or what, but the judge accepted them, meaning that the judge already would be willing to listen to more clarity when it comes to those things. I'm not saying those things are there and they need to be proven by the defense, but I'm saying the judge will welcome clarity to help his judgment when it comes to those things. Whether you say you were coerced, whether you say, yes, the gun is mine, but the gun was never there, it was planted. Now that's a different story, which that's why you even had the fact that they even had to call the second ballistic expert, the private one, it shows that they wanted to answer something. There is more to remember. Section 174, to make it easier, in my understanding, is that you go to the store, you steal maybe soap or whatever, and then I'm the only person who saw you. By whatever reason, I disappear. I'm nowhere to be found. Section 174 would apply there, because now there is no one who's going to talk to that. There is basically nothing to answer for, because I'm not going to volunteer and tell my story in any case. I'm saying I did not steal it. So someone must come and say, I saw you. Someone must come and give the events of what happened during that time. That's basically how I understood 174. So in this case, they are not saying proof. That's why legal aid said we disapprove this. because there might be something. It stands a less chance of winning. On my side, when I said yes, continue with it, I wanted to see the judgment from the judge, more than to say that actually there is no clarification that is needed from the defense side. I wanted, this was going to give a complexion of what to expect should the trial proceed, should the defense bring their own witnesses and bring their own people to come and debunk whatever that needs to be debunked.
Okay.
Exactly.
Well, the judge asked MNISI for feedback, and MNISI said that he needed time to consult with his clients on communication that they got from the committee that made the determination on this issue. He asked for a brief adjournment of 30 minutes, but before the adjournment could happen, the judge asked Advocate Baloyi if he had seen a notice. So he lifted up a piece of a paper, and it looked like it is a notice, and Baloyi said that they had not received it. So the judge asked all the legal counsel to read it and tell him what it said. MNISI said that it's a notice of motion, and this is the procedure that they indicated from the beginning when the members of the correctional services came to court, that the procedure that they followed earlier was very irregular, and the procedure that they had done, or what they are now doing, is what was expected of them to have been done at the very beginning. So Ramasipili then said that one of his arguments was that at the time, the correctional officers came to court and wanted to approach the judge in chambers. This is after Judge Ratamkwatleng made that ruling that accused number 5 be relocated back to Luikop prison from Kgoshimamphuru, because it wasn't working in terms of having the court start on time. He always came late, and sometimes he would protest because he was having trouble with the conditions that he was imprisoned in Kgoshimamphuru. So that was creating a delay in the starting of the case. So now that notice of motion has been filed by the department. Okay, we don't know who filed it.
I mean,
yes.
Because I want to participate in that. I just want to clarify something. I hear that Senzo is saying about the gun, Mr. Anonymous. Is there any case against accused number 3, which was opened by the security company? No. Or yes, I don't know. But maybe the company reported it missing. You know, okay. The main aim is not that whether there was a case or whether there is something to answer for, or whether there is a case. Sorry, the moment you say this is my gun, yes, this was my gun, that's where I'm standing. Whether someone decided to go and plant it, that's another story. The problem here is that the other case, that was not contested on the other case, right? Which eventually gave judgment that this guy is guilty. This is his gun. Was that ever contested? I doubt, because if it was contested and it was won, he wouldn't be there. Now, we are looking past that. Whether someone decided to create a case and it succeeded. It's like the situation of accused number 1 with regards to the case that is serving now. You know, did you see how the approach was when it comes to that case? Because that court is not there to look at that case as in, was this case done properly or not? The court is there to say, this person did 1, 2, 3. This court found 1, 2, 3. This is not an appeal court of that some sort. No, they are dealing with the merits at the time. You are a prisoner. That's it. And that's how. I remember we had an argument about that. That there were things that we were doubting and what. But honestly speaking, that argument is not going to help when it comes to Pretoria High Court and Senzo's case. That's why they're not even ready to look at those cases. Even the defense, when they start to get into deep into those cases. They object. MNISI objected when they were getting on the merits of the case of accused number 3. So to ask that question, it is opening now more questions of Cleveland case, which is that court is not there to clarify Cleveland case. That court is there to say, okay, this gun was linked to Cleveland case and someone was arrested. And the same gun is linked to Senzo. The court is seized with that. It's dealing with the same gun that is linked to Senzo. Whether someone says it's a revolver, now it's another story that we can argue to debunk what is currently happening in that court. Because they are not saying, this is not accused number 3's gun. Have you ever heard MNISI say that? This is not accused number 3's gun. No. He's not dealing with that. He's not dealing with the credibility of that, whether that is the gun or not. He's dealing with issues such as people talking about revolver and all that. So that's what I think we need to look at. I know I'm not going to be famous today, but if you look at it, I mean, at the end of the day, that's how these courts work. You cannot take that away.
I guess for most of us, we're having difficulty because we there's still a lot of and things that don't make sense with regards to his firearm itself. So now you're telling us that just because accused number 3 admitted that the gun was theirs, that already means that there's a case that they have to answer to.
You know what, when I say that case that they have to answer to is, okay, accused number 3 can answer and say, but this gun was planted there. Yes, it is my gun, but it was planted there. But now that's when you are answering. Do you understand? I don't believe that gun was ever in that house. Not in a million times. I do not believe that that gun was ever in that house.
And there's also a question of bullets as well, because one bullet killed Senzo.
Yes.
Where is that bullet?
The one that killed Senzo. No one knows. Oh, isn't it the one that they claim it's shattered?
So what proof have they presented to the court that that is the one that is shattered? Because what we heard from Mangena is, you
are thinking too much. You are thinking too much. What you are literally saying is that for you to be found guilty, if you come, let's say you come with your gun here, let's make a scenario. You shoot me, and then by luck, by not my luck that day, the bullet that was used to shoot me disappears. It shoots and...
It's not about the bullet disappearing per se. It's about establishing a person died.
Yes.
Connecting the death and what killed that person to the firearm that you are saying belonged to accused number 3.
Yes.
That is that's
no,
where I'm
if you look at it that way, then you'll never find anyone guilty in most of these cases.
So just because they have a
if
gun,
the bullet perforates,
that means they did the crime.
Listen, if the bullet perforates and then the bullet disappears, the one that killed, and then you found a lot of bullets of the same gun down there, what then are you going to say? You're going to say, okay, I couldn't find that bullet that killed. You go free. Yes, your gun did shoot that day, but I couldn't find the bullet that killed the person.
There's also no speaking of the wound itself as to what kind of a bullet would have entered.
Remember the bullet that you say, in fact, let me take you back because I remember the same bullet that was found behind jars and all that. It's the bullet that they claim killed Senzo.
Is that what they are claiming?
Remember, we were talking about how it moved, apparently, according to the testimony, it shoot the door and then it moved back to the glasses. It was spinning. Mangena was even saying it lost, what is it called? Yeah, then it fell there. And then this great woman came and found it. After everyone had failed to find it. So the bullet is the one that was tested is the one, according to the evidence that was in that court. So Senzo was shot facing inside the house. The bullet went down from the top, from the chest down, and then it hit the door, lost the balance according to Mangena, and then sat behind the glasses.
Hi, Mr. Nonsa, if Kushowena.
No, don't get me wrong.
I feel so defeated.
I'm not saying that is the can. I can never say that. But all I'm saying is that what is happening there, what you see happening there, even section 174 was not going to succeed. All I wanted it for, if they were amenable to accept this situation, was where the judge was going to rule and how and on what, because this ruling, it had a chance of showing us what evidence is the judge relying on. So he was going to say, I do not accept 174 on the basis of 1, 2, 3, 4, 5.
Okay.
Therefore, then the defense will be in a better position. I think even themselves, they pushed it because of that.
Okay.
To close the loopholes. Yes. It was never to say, really, these people can. After reading about 174, I knew from there. That's why I was even reading it to you guys, because I knew from there it was never gonna be that easy.
Okay. Well, Ramosepeli said that one of his arguments was that at the time, the correctional officers came to court and wanted to approach the judge in chambers. And he said that once a court order had been made, the party that is aggrieved cannot now approach the presiding officer in chambers because the presiding officer is futus officio. All they need to do is to either review or appeal that decision, which he can see now that they have taken that recourse. Ngumalo agreed with MNISI and said it's procedure. While the judge asked Ngumalo, he even asked Ngumalo, citing the minister, is that procedure? Because on that application, it seemed that on that notice of motion, the minister, the national commissioner, and the head of Koshimampuru Correctional Center, as well as the head of Luikop Maximum Prison, were the applicants, according to Ramosepeli as he was looking at it, and they are not being cited according to him. He said that they are applicants. They are the ones who made the application. And he said that these are the parties that feel aggrieved by the court order, And now at this point, I was asking myself, but where is the legal counsel that actually filed the application? Where are they? Shouldn't they have been in court to speak to the application that they have drafted? How does these things work? So the judge asked how the minister is a party to this process, and honestly, I felt like it's a difficult. It was a pertinent question.
Yes, it was. This so-called application. As time went on, it looked like the owner of it was really answering on behalf of the people that should be answering.
It was the weirdest thing.
It gave that feeling Ngatubalo knew about it and he wrote it. it gave that feeling.
I
He
was also
fun-
tempted to ask, did he draft it? Is he the one who wrote that application?
Yeah, it looks like it had that feeling, because when he was asked about where the person is, instead of that, he's reading
Rule
section 49.
Yeah.
He's dealing with it. He's dealing with the merits of it. Why aren't you answering as to
Who the state prosecutor is?
Who's the
that?
attorney?
Hey. And the judge wanted the council to tell him what their views were on citing the minister, and how is he party to this process, because Minister of Correctional Services ungena kanjani, and I found it to be a very interesting and very good question. Ngumalo said that it's on the basis that he is the head of Correctional Services, and he's having an interest on the matter.
He is the head of the operation.
I don't know.
No, I think when you this is a situation where you use your powers to the point where they even confuse you. There was no need
to mention the
minister. I'm sure he's even surprised at this point in time. Why am I being mentioned? It was wrong. It was wrong because remember, a minister is a politician. What has the politician have to do with the court's proceedings? Is that not tantamount to interference?
Yes.
Of the proceedings?
It is.
That's why the judge kept on asking. It was wrong of the so-called attorney to include the minister. It was very wrong. I think they are not briefed as to what is the job of the minister. They might as well also have CC'd the president, because they are entering that territory.
Yes, might as well just CC the president as well. It's just a political. It's now a political.
I think this so-called attorney, if it's not an advocate purporting to be an attorney, just a simple attorney, he got it all wrong. But I still it seems as if I've had this type of arguments being ventilated in that court. I'm not sure, but it feels like that. It feels like they are familiar. Familiar spirits. They keep on coming back. But it's okay. We rely on the fact that during the break, perhaps there was a poor attorney that needed to rush there and mediate the situation.
Okay.
Yeah.
The judge asked what Rule 49 stated, and Baloi said that looking at the document, it is saying that the notice of intention to appeal the order that was made by the court, and they are requesting reasons. And he said, and I quote, "So I suppose it's Rule 49 of the Uniform Rules of Court," end quote. So the judge wanted to know what it said. An advocate Baloi said that before proceeding with the application for leave to appeal, the reasons should be sought for the order that was made by the court. And he said that he thinks that is the purpose of the notice. So this is supposed to be an appeal. But the way Advocate Baloi was explaining it, it didn't sound like it's an appeal. It sounded like these applicants wanted reasons as to why the judge ruled how they ruled.
Not only he just wanted the reasons, he later on says that he wanted them written down.
Yes, wanted them.
When the judge kept on saying, but they were here in court, should we give them a record because they were here in court? They even answered some of the questions that were here. So then he talked about them being written down formally.
He said it. He said the judge asked what happens because, as he understands, the representatives of correctional services were in court when that order was made. They even proffered some submissions. Now they want the reasons. Baloyi said that written reasons is what they seeked or what they sought to achieve.
But that was not down. From what I'm picking, it was not written down that they wanted written reasons. So only a person who is aware of what perhaps this attorney was looking for can actually come with such excuse.
You're making a valid point there.
It was not written down.
Baloyi asked the judge who was the state attorney. Baloyi asked the one mentioned in the documents or just generally. The judge said the one mentioned in the documents. Hi, Advocate Baloyi did not answer this question. He now came with the Rule 49C of the Uniform Court Rule, which says that when giving an order, the court declares that the reasons for the order will be furnished to any of the parties on application. Such application shall be delivered within 10 days after the date of the order. So in essence, they're just seeking the reasons for the order. But who's the state attorney?
No, that is not easy to come. And at some point, I could see the annoyed face of the judge. Yeah, he was annoyed. More so when it comes to CCing the politicians. It was uncalled for.
Yeah. So the judge asked Baloyi to call the state attorney to court because he is not understanding what he wants to say. And he ordered for that 30-minute adjournment that Advocate MNISI had asked for. And MNISI said that they could adjourn for as long as they would be waiting for the arrival of that state attorney. The judge said, he's not coming.
You see what... it seems as if he also believed what I'm believing. that there was never an attorney that it would be outside of that court already.
Oh my God.
Yeah, so it's one of those things that we have to look at, and obviously it falls on the lap of defense again as time wasting. Don't worry. But we see where these things are mushrooming from, in my opinion.
Well, the judge said that the state attorney must come and tell him if he did not receive those reasons from his client, because the first thing an attorney, when they take instructions, this is the first thing that they tell them. What is it? What happened? Right? That's what an attorney does. And the gentlemen on that notice of motion were also here in court. The commissioner, the head of the prisons, the head of the Luiko prison, the head of Hoshimampuru, that's CMAX. Two of them came 2 days in a row.
Yeah.
And they still want reasons. And the judge was like, maybe they should just give them a copy of the transcript so that they can listen to it again.
You could understand why it would pain the state to actually have that judgment being given to accused number 5 as a person who needed to be moved. Because what it seems to be doing, it actually affirms in one way or another what these other accused are saying they have went through. And when you are getting those ones dished like that to say that, yes, this person needs to move because he could have been violated one way or another, it seems to suggest that because they are still under states, perhaps then there was a bit of truth in what was said by the other accused, that they were coerced. So it pains them because now they want a reason as to why was it given.
You know, in situations like this, I always wonder, doesn't correctional services have their own legal?
They definitely should have. They definitely
Like,
should
it's
have.
always like they're scrambling every time in situations like this. Look at what was happening. Accused number 5 was saying, I was being ignored. I even wrote a letter. My letter is not attended to. Where is the legal facility of correctional services itself? And I believe SAPS also should have the same, because you find people getting off there by the court with misdemeanors and things that could have easily been avoided had they had consultations with a lawyer prior to making arrests. Do you understand? So I'm always wondering, where is the legal department in each of these facilities, because they are dealing with lawyers, and you can tell that every time they have to deal with lawyers, they are found scrambling all the time. They are found not knowing what to do, what to say. They just look unprepared. Even this whole accused number 5 situation, it was so weird. It was weird.
It was very disturbing. But unfortunately, it does not look good to the states when it comes to these things now. You know, they are sort of saying something. So people are going to look for answers as to say, why did you give this one? Why, you know, because it doesn't make them look good.
It doesn't. And you also have to consider that letter that the correctional services released on the same day that the judge made the order. It also didn't have a person who wrote that letter. We are used to the spokesperson being quoted there at the bottom. Something. It didn't have anyone who wrote that letter. And now this application is being made. It has no state attorney. Kwenzakalani? What's going on?
I assess.
Well, he said that the communication between himself and legal aid stopped until that day. Then today they availed themselves to court during the adjournment. And he communicated that the position of the client, Mr. Mnube and Mr. Sibia, who are still of the opinion that it would be in the best interest of justice from their point of view that they bring the section 174. Then after that, they started to ask him questions that he was not in a position to respond to. Then he requested legal aid to go and attend to those questions and answer those questions, as they are questions that should be answered by legal aid. He said that they will still go through some deliberations around the questions that they had been asking legal aid. There was a moment when they were requested to go and see the court in chambers with the team from the state attorney, and he said that they had not yet finalized the discussion, but he stated to them very clearly that it would be a challenge on his part to go and sit for 4 weeks in preparation of the 174 without any reimbursement. He said it's going to be a very serious challenge. So in other words, he'd never he'd need to go and sit for 4 weeks preparing for this section 174, because it's going to be a very detailed section 174, and at the end of it he'd just be seated there fully concentrated on this application, not to be involved in other work. So he said that he doesn't think that he'd be in a position to do that. He's already done that. Without
being paid.
Yes. And he's already done that since January, and he has gone through 40,000 pages, and he said that he doesn't even want to go there, you know. This to me also sent a signal that he might not have been compensated for that period while he was going through the 40,000 pages by legal aid.
It does seem like that there was no compensation for this, which is, we talked about this,
that he had
for
to do.
For lawyers to actually go on and read the record again.
Yes.
You get paid.
You get paid for it. And if a new lawyer would have been assigned and Advocate MNISI not taken over, certainly the new lawyer was going to be asking for compensation to do that, because in itself it's work. You are working. It's not like you are chilling on holiday. You are working, you are going through the record. It's a job. Every day it requires your full attention. So if you abandon it and look for work somewhere else, when are you going to finish, and what kind of a representation are you going to give to your client? So it's weird. I don't know what to make of this, in how legal aid treats lawyers. it's something else. Now I understand the kind of quality that is given when it comes to representation of people that are accused. And the ones that are unfortunately victims of this are people that are falsely accused. They don't get the best legal representation. Now I'm starting to connect the dots and see how it happens, because
it is scary to know that you have, if you were to do something or something was to happen, you'd have to rely on the controlled money controlled by someone else who says he's looking out for you, only to find that they are looking out for budget or whatever. I don't know what it is that they are looking out for.
This expectation of the defense counsel to work for free as well.
Yeah.
Is kind of like, so they don't consider you studying the case as a part of work. The only thing they consider work is a court appearance. While a private attorney bills you for that.
Yes.
They bill you for even writing a letter.
Yes.
For drafting a letter on your behalf, you are billed.
Yes.
And legal aid lawyers are expected to do this, studying for free. Going through the record, they're expected to do it for free. And in fact, they're discouraging them as well, it feels. It's almost like they're putting them in a position where they're like, fuck, I give up. Go get yourself another lawyer.
Yeah.
That's the pressure that I'm kind of seeing being put here, that he might as well just quit and give this case to
and
another
such
lawyer.
words, they are thrown around for fun. More so when it comes to MNISI. I think we have been seeing this since Tifo's time.
Yes.
Now we saw it with also with Titi. Even Titi suffered the same fate. Ngomezulu suffered the same fate. It was better with Ramsipil, but I don't think it will be better now if he was to take over. Now we're seeing it with MNISI. So anyone who seems to put a fight, a fair fight, so one way or another, there is something that is going to, because in any case, you rely, whether you like it or not, you rely on government,
Yes.
which is the state, to assist you. So can we say you get a fair trial if such things are stopped?
Your legal representation is hamstrung. Like, it's when they are
If
ready
we are
to
only
go,
given
like,
one way to win a case, for example, in this case, it's one way. You are not given a fair trial like someone who would use the private lawyers. You are only given one way that would sort of save money. If you like, I don't know why they save it, but that's what you are given. Deal with it in this way. Go to the court, defend yourself, even if the case is not there. Unless the judge pronounces such, then you only have one way. Because there are many ways you can look at this. A judge can say, no, there's no evidence. I'm not continuing this case, which is most likely not going to happen in most of these cases. You can bring that 174 yourself. Say, this is 174. I don't think you have enough or you have evidence at all against my client. Or you can go and defend whatever that the state has presented, which in this case, they have two things that could have happened already predetermined for them. That is not going to happen for you. Go through the agony of going through this case until you finish it.
Well, MNISI said that he's not in a position to read those 40,000 pages for the second time again. The only reason why he would be this unwilling is is if legal aid did not come through with the payment the last time. That's just my opinion, When he went through the 40,000 pages, it seems like he wasn't well compensated for it. And provided also shady tactics of releasing. Now we saw articles a couple of weeks ago where they were saying that legal aid had spent 6 million on the defense. I don't know why that needed to be made public information in that manner. Especially considering the fact that it's not quite the defense's doing that the state's case has taken 2 years. It's all on the state, in my opinion.
Again, you see, I like the fact that you said on your opinion.
In my opinion.
That's where the problem is. That is where the problem is. It's in your opinion, but according to other people who are out there, that is not perhaps what they are saying. There could be something else they are saying. The
that
state,
the defense is dragging.
Because some of these things have been done, I would say, in a manner that portrays the defense as time wasters. One can even argue as further as D4 to say that those were the people that were looked at as people who were wasting time at the time. Up until today, the defense is still looked at as people who are wasting time.
But how? Because they have not presented their case yet.
They've been verified by the media. The very same media is the one that allowed this presentation of the cost. They were
moving at the state's pace. The state was the driver. They were the ones leading. They were going with the direction of the state. So how is that their fault?
How about the section 174? Mm-hmm. That is now in their control. Mm-hmm. Other people are saying this is time wasting also.
But it's the law. It's the law. If they need their clients are asking for it, then they must bypass it because they are afraid of being accused of wasting time. Their clients want this section 174. They need to do it because their clients are asking for it.
You are right. They need to do it, but how it has been portrayed, and hence MNISI had to clarify that this shouldn't be made to look like it's me in this case, which has been happening in that court.
Yes.
It is not wrong of MNISI to actually submit that, in my opinion. It has been made, that's how things have been portrayed. That's how things have been projected in that court, if you ask me, in my opinion. So that's what the media is eating. We have people who are sitting in that court and they're eating that. To such an extent that they would even go as further as bringing this legal aid that had to come and answer and defend the position of the money. Who created that platform? It's the media.
Had said something very interesting in another podcast I watched, that whenever a black lawyer is presiding over a very big case, there will be this witch hunt.
Yes.
And even the state itself will even want to go as not want to pay for legal representation coming from a lawyer of a specific color.
Yes.
But then you see right now there's a Hofmeyer. Hofmeyer was in the Zondo Commission, and now she's going to be in the Madlanga Commission, and already she has started asking questions targeted at Kwanazi and stuff. So I don't see the media doing anything to her. I don't see the finances of her presentation of the state being questioned.
Yes.
I don't see it.
And you're probably not going to see it.
And every time, even with the former president, when he was taken to court, when he was represented by lawyers of the other color, we didn't see that. But when it becomes Kakani, now stuff like that is now made headlines of newspapers.
There are more examples. It's like now, we have a situation where we have accused that are representing themselves.
Yes.
One is scammer, the other one is the other guy. just for no reason, if you ask me, really no reason, a man is saying, I'm fine. It will be enough for a black person to say, I'm fine, and the court will proceed.
Yeah.
But they have decided to refer this one to the psychiatrist.
Yes.
That's where you see the differences.
To have a mental checkup.
Yes.
To evaluate if he's fine.
Exactly.
but that hardly happens.
You can never see it with the other guy who's representing himself. You can never see it.
There's also another one who got dismissed because he had been diagnosed with a mental illness after ending the life of a female. They did.
So there are other avenues that are meant for certain people, and they're not meant for other people. So it's a norm.
So the judge wanted to know what was his instructions from his client, and MNISI said that his client wanted to go through with the Section 174 application, but the challenge is who's going to finance it. Ramasipili said that he will not be talking about finances. Guys, apologies, we have a third host today because it's a matter that should be in the private sphere, and they have been informed by legal aid that the prospects of success for this application are low. They told their clients that they don't have a leg to stand on the 174 application. So I have a question, Mr. Anonymous, but you've answered it, so I guess I will go through and just...
No, you can ask it.
But you've answered it. The question as to why, how did they determine that? How do they determine that they don't have a leg to stand on? What is the formula? What is the calculation? But you've already...
it's on the basis that there are clarity that are needed from the defense.
So Ramasipili said that he'll have to take instructions again from Mr. Ntanzi, having been advised that they don't have a leg to stand on when it comes to the Section 174, and yet they are given the green light to go, but the view is that there is no leg to stand on, and he said he'll have to take instructions and give his client his final view, So that was pretty much what was happening. And also the judge asked Ramasipili, does your client want to proceed with the application? And Ramasipili said yes, he does. Ngumalo said the Constitutional Case Management Committee from the Legal Aid Board said yesterday, and he said that he received a response, as he has indicated earlier, that his client's request was declined. But he wishes to bring to the attention of the court that these issues of Section 174 application is something that they have been discussing with his client. It's not something that they took overnight. There were instructions all along from his client that he should bring such an application, of which he's prepared to do so. And he said that he was going to request the court to grant him the indulgence. And he said he had already started to draft the application. So he said he was asking for a week from today.
This is what you don't give to Ngumalo. I know many of you say he does not give freebies to other people. If you can tell me why he would mention that it is something they have been discussing with his client.
Why?
I'm asking you.
I don't know.
He was literally saying that why he's going to take short time is because it has been on the cards for long. So he has started drafting long time ago.
Okay.
Because he has been instructed like that since the start of this trial, according to what Ngumalo is saying. So in a sense, it's saying to the judge, don't use my timeline to actually mark other defense lawyers, because on my side I have been instructed like this since,
which is like 2 years.
Exactly.
No wonder why when some witnesses are coming, I have no further questions. He was collecting what he needs for this application.
And whether right you here, like him or you don't like him, he chooses his space properly. and he works it. Whether it's going to be good or not, and someone was saying that I'm saying Ngumalo is true. I'm not happy, Vele, about sometimes not putting the weight. I'm not happy about that. But honestly speaking, if we forget about the fact that we even need weights when it comes to this case, he picks
his battles. True. He picks his battles. So the judge now had questions for legal aid, and he started off by asking the legal aid representative, saying that when you assumed your mandate to fund the accused, was it to fund them through the legal process, or did you have conditions? The legal aid
very solid question from the judge, honestly speaking. It's a solid question.
The legal aid representative said that they did undertake to fund them through the whole process. But the question that came before the Constitutional Case Management Committee was whether they would fund a 4-week preparation for a 174 application. And it was put before them, and a decision was made that they won't fund them. She said that they won't stop them from doing a 174 because that is part of the CPA, the Criminal Procedure Act.
In a nutshell, the instructing attorney was literally saying that they're gonna have to work for free. Yes. Can she do that?
I don't think so.
Can she be the one to deal with that part?
I don't think she would work for free, but she was asking them to do that. But the Constitutional Committee said that they are of the view that to pay for an additional 4 weeks to prepare for a 174, they were not amendable to that. And the judge asked, but you are prepared to fund an application for 174? Legal aid representative Ms. Flavia said that she said it's their appearances, and in terms of the tariff, they are entitled to fees in terms of the tariff. They have 2-hour preparation per day plus obviously the court appearance, but in addition to that, legal aid is not prepared to give the additional amount. So she was saying it's 2-hour preparations. So it sounded like it's two-hour preparations. That's like 2 days of 2-hour preparations, which is a trial day plus the trial day itself. So it seemed like they are assuming that this whole application process would spend 1 day or would be done in 1 day, where the defense present this argument or the application, and then the state responds, and then we wait for the judge to make the verdict. It's like all of these things are just going to happen in 1 day, starting in the morning with them having their 2 hours to draft. So it to me, it just sounded like, okay, the expectation is that this whole application is supposed to take 1 day.
It sounded like he's saying, if there is no court sitting, then that 2 hours is not going to be counted.
And the judge asked MNISI why he needed to prepare for 4 weeks. MNISI said that it was his estimation. He has taken into account the issue that he needs to deal with and the volume of work that he needs to go through in preparation for this application. He has taken into account the number of the accused as well that he's representing.
If you are fair and really you were to judge this, you would need to look at, he literally said it's 2 weeks per person. Now 4 weeks looks long, but it's 2 weeks per person.
And for very crucial.
And if you were to consider the submission of Ngumalo, this is something that emanated with the other accused as soon as the case finished. When they realized that this guy has nothing on us, then they started instructing their attorneys, which some are new to them as their lawyers, like accused number one. So you cannot use the fact that MNISI was given time that he was not paid for to read and familiarize himself with accused number one's defense and form a defense for accused number one.
Yes.
And then say because of that, then he should be in a position to prepare for a week. There is no such. But for yes, Gucci, I have one project that took me a month to finish. Just finished it as the month finishes. Honestly speaking, I'm talking about a private company where really pressure is. Can you imagine reading? Can you imagine reading?
I can't. I'm already struggling.
You know, I'm talking about a mere coding and then preparing a report. You know,
drafting.
And now we are talking about drafting, where you are expected to draft properly. You are expected to make it easier for the judge to read your stuff. There is a certain way. Yes, that's what you do every day. But can we really assume that, considering the fact that accused number one has what they claim is a confession, considering the fact that was accepted by the judge, by the way, to debunk that is not going to be an easy thing. And then considering the fact that accused number two, there is this so-called gun that is hanging on his head.
Yes.
You are defending these people in a different basis. They all have their different ways of defending them.
And MNISI's clients, both of them are very important and central to this case.
So you can't just say, oh, like Ngumalo. You look at Ngumalo, if you go read that record, you probably can count how many times accused number 4 appears. In fact, I could argue that he appears more when Gininde was trying to create this DNA situation.
The
that
hat, he said.
I say to create because he still believed that they were included.
Yes,
but
the DNA
expert
reading
came and said no, they were excluded.
Yes.
So it's a situation that was created for one way or another for certain reasons, because it was clearly seeming that the case was finishing with that accused number 4 actually being attested for.
Yes. So that has been quite an interesting journey. And now that we're looking at it as well, it's like, okay, the amount of work that Ngumalo will have to do compared to the one Advocate MNISI is going to have to do, they are not the same. They are not the same.
No, they are not the same.
No, they're not. So MNISI also pointed out that this is different.
Even Ramosipila has harder work than, and then in fact Ramosipila asked for 2 weeks, right?
Yeah.
So MNISI is not different from what Ramosipila asked for.
He's asking for. They are not far off. It's just that he has 2.
Which you have to times that by 2.
Yes. So, because the preparation will be done when the court is not sitting, MNISI said that he requested some clarification from them as to what do they mean by that. He's unable to get a precise answer as to whether or not they are saying it is fine, you can go and prepare, but we'll pay you for your preparations for the day for 2 hours, irrespective of whether you're preparing for 7 hours per day. So legal aid is basically saying that this application can be done in one day.
Can they do it? Didn't they take one person? Saying how do you donate here? There are many ways. You can press that dollar that you see on the comments there. There's a $sign there. You can donate like that, or you can also join membership. Use the button join. If you are using an app, YouTube app, the red one, you subscribe and you join. That's one way you can actually help the channel. We appreciate that in advance. Thank you.
Yes. So also, people are like, lawyers do this every day. They are not drafting every day. There was an incident where there was, I don't know if I should talk about this, Mr. Anonymous, but we had an incident where one person, an attorney had sent a letter that was drafted, and it was drafted by their junior, and you could tell
Exactly, and you get lambasted. You know what? I also had a contract that I wanted to create.
You get that,
I wanted a lawyer to create for me. This lawyer is a friend of mine. So what happened is, she gave that to a junior. We were both laughing. You guys don't understand how much these lawyers we were both laughing. Like we were looking at the mistakes, the manner in which my name was written. It was simple one paper of a contract, and I needed to give that to people that I needed to give it to. It was worse, spelling everything, it was worse. So they need, it takes time to get used to these things of drafting and whatnot. So you need seniors to draft such things, more so for High Court.
Yes.
You don't just draft, and otherwise you'll be lambasted. It's
not a once-off thing where you just you draft, you read, you go back, you polish. You have to read those many textbooks and put the sections that support what you're saying. Yeah, this is not, guys. We would be all of us would be lawyers if it was that simple. Okay, it's not. That's why they cost so much.
It is not an easy thing.
So the judge asked Ms. Flavia from Legal Aid to come and explain again. And Legal Aid said that they are only allowed to charge a tariff fee of 2 hours per pre-trial preparation and won't be paid for weeks preparation at home. They won't be paying for that. Okay.
In a sense, what they've just told you is that if you don't have money, you are screwed.
Yeah, basically. Yes. So the Legal Aid representative said that they will get the tariff of 2 hours in trial preparation plus the trial. They also get to increase fees per trial date. So they don't get the tariff. They've got special fees for the trial day, and committee was of the opinion that was sufficient. I'd really like to see this cost benefit calculation that they have going on. It looks very interesting. I wonder what are the variables that are put in as they estimate and they make the calculations. What is the formula? It is very interesting to find out. So the judge asked MNISI how long he thinks he'll need again. MNISI said that in January, he said, remember, that he would be completing to read those 40,000 pages on the record at a specific date. And then came that date, he had to make a request for a further postponement. And then he was lambasted. He said that he didn't want to go through that experience again in preparation for this, but still, without clear terms with regard to payment, he said that he won't be preparing anything. What he's understanding from Legal Aid is that they are not willing to reimburse a person who needs to prepare for this application on behalf of the accused. And the judge said that he thought that he had read the record again, and he was in court when the matter commenced. Then after that, he was granted 4 months and 3 weeks reading. And he asked him, so you still want to read the same record which you have read and listened to in court? MNISI said that it's different now because he'll have to bring an application in terms of 174. He'll have to revisit the record and find those points that he wants to include in his 174. And then the judge said, you are saying you're no longer wanting to represent your clients until the Legal Aid Board says that they'll pay you for 4 weeks or whatever.
Making him a person who's revolting against these people and knowing these systems that are put in place for lawyers, discipline and whatnot. They sure know how to dig for each other, these lawyers. If you really want a profession that is so dark, I think become a lawyer.
Yeah, it's very dark and toxic.
Hambe uba a lawyer.
MNISI said that he never said that. That is the problem. He thinks he's being misinterpreted here, and that has always been the perception in the mind of Legal Aid South Africa, that he's after money. He said, I'm not after money. I'm only requesting for assistance. But they are saying that they are not in a position to assist. And that request is not coming from him. It comes from the accused. And if the court says, therefore, I'm saying I'm no longer representing the accused, well, that does not come from me. If that is what the court has in mind, then we can take it from there. Then we'll have to find a middle ground. And I don't want to, and I'm requesting with due respect that this trial should not be about me, is what MNISI said. I should not be the centerpiece of this trial.
You should have told that your bride are sitting behind you.
Who? Oh, oh, I got it. He said, I've been requesting to come and assist these accused here, and up to this far, I have done the best that I can. But for the focus of this trial to change from this accused person to be on me, I think that is very unfair. But if there is a perception that is being created that I'm therefore saying that I no longer intend to represent the accused person, then let those who are entertaining that perception tell me straight that I'm no longer fit to represent these accused persons. Hey, I felt that. I felt that, maybe accused number one should have from the beginning asked for that new lawyer. Maybe. I mean, maybe that would have been better because we were given the impression.
They are misusing MNISI. And I have a problem with the black profession being underpaid for merely being black, in my opinion. I mean, at the end of the day, what MNISI is doing is that is what puts the bread.
Yes,
we cannot ignore that. As much as
children,
as much as this case is sensitive, also in dealing with the people such as Bontanzi, but at the end of the day, MNISI needs to come back with something.
Yes.
So we cannot ignore that. And we cannot ignore what was said by people like Bo Ike. Ike talked about this.
Yes.
Where black lawyers are verified for asking for more money and all that. It is not something that we can say we haven't seen. We are seeing such things. We are seeing they are happening in front of our eyes, in my opinion. So to make him look like this money-hungry person, for a person who's applying for Section 174, which if it succeeds, it would stop this whole bleeding of money. I don't know.
Now I'm defeated because I'm thinking, I mean, as legal aid, wouldn't you be happy for the Section 174 to
succeed? Yes, definitely they would.
That means costs cut, that means you don't have to spend any more money. But here you are now, not participating in it in a way that I had expected. I'm kind of shocked, really. But it is what it is. MNISI said that they are requesting that we should bring this 174 application. Ramasipili said that he was amendable to the 2-hour preparation, and he said he had already started drafting his application for Section 174, and he already told his client. So Ngumalo said that it must be made clear that when the court is not sitting, legal aid is not paying.
Exactly. See Ngumalo again.
Wow. He said that in this trial, like today in the trial preparation, 2 hours, then there's payment. Then there's payment for court appearance. The issue with MNISI is that when a matter is postponed, let's say for 2 weeks or for a week, then there's no payment at all. But he's saying that on top of that, with or without payment, he can proceed in a week. The judge asked MNISI if a week to prepare would be sufficient, and MNISI said, if I come here and present a document that is not up to standard, I would request that I should not be denigrated because of the lack of proper preparation, because of the shady work I would have presented. and 1 week preparation for him, he said, will not do. And Baloyi said that before Advocate Nkumalo spoke, he was just asking himself, why can't the court days be used for preparation? But then he said that if the court is not sitting, then Legal Aid South Africa is not paying, because if it were paying, then those days could be used for preparation. Yes, this is for those of the people who are saying, oh, they're milking states' money. Nizwilege. When they are not appearing before court, they are not getting paid. So, again, lentole of hating on black professionals. It's really not nice to see and watch. It's distasteful. But it sounds like it's just about tariffs. And he suggested that there be further consultations between Council and Legal Aid South Africa. Perhaps a middle course can be found. And they suggested that the parties try and find each other. And he suggested that they take the long adjournment and see if the parties cannot find each other. So the judge asked if it's about money. And then he giggled and then he laughed as if he came out of his retirement to work for free. You know, I found that very disturbing. Is it about money? I mean, I'm like, you use petrol to come to court every day. Petrol cannot be bought with stones. It requires money. So I don't understand why this giggling and this hey, yes. I'm like, but you came out of retirement.
That's what this guy was talking about, Ike. That these judges also have problems sometimes with these lawyers getting paid.
They pocket watch. Pocket watch. That's what I was saying, that they will see a young lawyer driving an expensive car and they're like, in my days when I was a lawyer, we were not even driving this kind of cars. And then they limit the money, the cut off the budget. I'm like, what? Being a lawyer is tough in this country, especially one of this color. I don't know what I would do. The depression I would have.
Just press the like button, guys. Thank you in advance. Please press the like button. Press it, guys, please.
Baloyi said that it's about the tariffs. If the preparation takes place during the normal court hours, maybe they might consider paying for the preparation. Then the judge asked that it doesn't change their stance. From what he understands, it's a fixed tariff, but they have agreed upon as a committee. Baloyi said that the issue is the 4 weeks, and Ramasipili said that he will be identifying issues in the transcripts. He said that this is not like a shoplifting case of 2 witnesses in a magistrate court matter where the state finalizes with 2 witnesses. Then you apply for 174 where somebody stole a perfume at a store. But this is a serious matter where you need to identify crispy, the matters you want to raise. And as Mr. MNISI said, you don't want to bring a half-baked case to court. The issue is not finances per se. The issue is preparation time. And Baloyi said that they should find common ground after the judge asked what should be done. MNISI said that he was a creature of instruction. He must just take instructions from legal aid directly and from his clients insofar as this case is concerned. But in issues such as this one, it is legal aid who must instruct him on what to do. If the client says we want this, it is legal aid who must come and instruct him what to do. If the client says that this is what they want, legal aid must be them who tell the client that that is not possible or that is possible. It is not for him to come and stand there and try to convince legal aid that this is possible, because he said he's a creature of instructions. He said legal aid says do it, he will do it. Don't do it, then he won't do it. It's like he's a pawn. And he even said, I'm a horse. I'm sent here and there. I mustn't ask why. And MNISI said that it's a discussion that must take place between legal aid and the client, and they have finalized. Then legal aid will come to him and say that these are the instructions that will be taken from them. But over and above that, legal aid is not only an attorney but also a funder of this whole legal process. And the judge asked him if they paid him or for reading the record, and MNISI said he would rather not go there. It's also a very sad story, but he'd rather not go there. So after the long adjournment, MNISI said that his position still stands. The accused are saying that they would have wished to bring the Section 174, but if circumstances do not permit, they will not bring it. He also asked that it be confirmed with them. Ramasipili said he confirmed with Ntanzi. It is still his wishes to bring forth the application, and he suggested that by the 18th, it be the date that they be done, and maybe they can come back, whoever wants to apply, and finish the written heads. Then after they have been furnished to the state, will be afforded some time to respond, and if there's anything to be ironed with the instructing attorneys, it will be done in that period. Ngumalo said he has made his decision. He will be communicating with Balo in terms of the filing. MSHOLOLO still stood by the submission that Mr. Ntuli will not be bringing the application for discharging, and Ngumalo selected the 15th of August, next week Friday. He said that by then he would have submitted the heads of argument, and the state estimated that they will be responding by the 22nd of August. That's when they will be done, having gone through the heads of argument that would have been presented by Ngumalo. They would need 3 days, and then after those 3 days, then they can come to court with a response. So the court ordered that the heads be filed on the 15th and the response on the 22nd of August, and the argument will be happening on the 25th, from what I heard. So, yeah, itelendlela. Sisazoyihamba kodwa.
I cannot shake it off.
Yeah.
About accused number 5, what
Yes.
Difo said. I can't shake it off.
Can you go into what did Difo say at the beginning, at the very, 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 very beginning of this trial in 2022?
He said accused number 5's mandate was to, according to him, in a nutshell, this is was to throw everyone under the bus as a person who was a drive-away person, stuff like that. I don't know, but when you see things like this happening,
you are reminded.
It just hits you in a different way. I'm not saying, but all is alleged, but yeah, it just doesn't make sense.
I don't understand the abandoning of this application.
It has not been.
I don't understand
to me,
it.
It has
Maybe
not been,
someone can help explain it to us, because now I don't get it.
It has not been explained as to why.
get it.
Is it some decision that was taken on a basis of an outcome? Was it a decision that was the position of accused number 5 long time ago that he wants to continue with the case? That's something, because you are living something that you have nothing to lose on. There is basically literally nothing to lose on. If you are denied that 174, it's okay. You can still then go proceed on the same way that you want to take. But to limit yourself into one way of defending yourself, while there are many other options and avenues that you can actually look at, it leaves a lot to desire.
It's like, what is happening after your fellow planet colleagues fought such a good fight?
Yeah.
To have accused number 5.
Because of the time and the fact that I have my kid here and that I still need to drive with, I don't think I'm gonna take calls today. Can we do that tomorrow?
Okay. I'll prepare a
with
little
respect.
something tomorrow.
Yes.
But we'll be back tomorrow so that we can take your phone call, guys.
Yeah, with respect. But just to thank everyone that was here. Is Chuku Anna, Doka Shabalala, Lindiwe, Laura was here, Sizwe was here, Samuel Radebe was here, Lee Boshomane was here, Mhlangabezi Sly was here, Cindy was here, and Ntombi Mhlanga was here, Lilo was here, Tobega D was here. Uncle Nays was here. Dipuo was here. SD Kundunkomo was here. Michelle Lee was here. Raul Mtrobel was here. Tembelani Kanye was here. Siba was here. Hamilton Mezuze was here. Chad was here. Bongi was here. Chris Neo Sehlako Nebza was here. Refilwe was here. Snesbia was here. Gugu K47 was here. Crash was here. Thomas Mkabela was here. Mlambo Designs was here. Backyard Mechanic was here. Hlubigazi was here. Timkulu D was here. Mr. KG was here. Zizamele Picture Shabalala was here. Nkosinati Zagwe was here. Nangelo was here. Rulani Maluleka was here. Boto Ramukate was here. Lindy Webembe was here. Mzwake Radebe was here. Sfiso Sindani was here. Zintle Nziba was here. Babalo Pakeli was here. Nkosimko was here. BBM was here. Manchester John was here. Pamela Ntomfuti Jabulile was here. Mpo was here. Lindeni Hadebe was here. Lucas Nkosi was here. Khona ngimshile. Angazi Sizwe 18 was here. Utuku Ana also was here. Shingi was here. Our member, my daughter. Ubani ngimshile. Siphombata was here. In China ngecishe. Uphumlani Mahaiya was here. Tomani Dube was here. Sizwe 18 was here. Yebo kunjalo. Sizohamba mjani. Ngicabanga ukuthi nginibambe nonke bafowethu. If I missed you, it's not my doing.
Let me also say thank you to Net.
Yes. Ngokukhethekile. Siyabonga kakhulu. Really.
Thank you.
Other people basebenzele bomnyameni kodwa izinto zabo ziyakhanya. Siyabonga kakhulu. Thank you very much. And to everyone who's subscribing, to everyone who's liking, remember to like. Says Sibanda Skatele nange phakamise isandla egcineni. Please press the like button. Someone is talking about co-hosting. I think I saw something like that. Uthi nifuna ukuzo-co-hosta. Hey.
Yes.
Yeah, someone, I just missed it. Sibonga kakhulu kodwa kini nonke nje nibalekile. Michelle Lee Zizamele hey madoda sibonge nje sibonga kakhulu ma members. Thank you guys for keeping us and keeping the lights. Without you asilutho nganza kwethu. Siyabonga kakhulu. uNkulunkulu anibusise nibe nobuthongo obuhle. God bless you. May you be well rested for the next day. Ubani, yes, thank you. Asvale, amen.
It's a wrap, guys.